Good evening, everyone. We are here. Finally, the day has come, the NFL draft. So, this is going to be an abbreviated Karen Reed NFL draft discussion. So, let's first get into the Karen Reed case. The last 2 days have been kind of eye opening, if it were. You immediately kind of see exactly what the difference is in how the case is being presented. Because ADA Lally certainly had a different style of how to present the case, as opposed to Special ADA Brennan, how everything is kind of cohesive, everything's going together, how it's being presented. And that's really a big difference between these cases, the first trial in this trial right now. Um, even just, and I would be remiss to saying it's like it matters a ton watching the defendant sit there after Special AD Brennan does the direct examination. Alan Jackson or David Yannetti does the cross, followed by the redirect, which was already pre-planned because Special AD Brennan knows exactly what Alan Jackson or David Yannetti are going to ask. So that when they recross, any kind of points they made during cross or recross are essentially neutralized when the defendant's own words corroborate the testimony. I think it was the I hit him, whether it was 2 times or whether it was 3 times. It's like not a lot of time should have been spent on that. It should not have been the 2 hours it felt they were doing. It's like when you're doing a cross examination, you make your points and then you sit down. You don't just beat a dead horse. And that's kind of what they were doing. They were splitting hairs because the jury's going to think to himself, all right, so we can all agree she said it at least 2 times. So does it matter that this guy said it was 2 times last time and 3 times this time, or vice versa, or he said this in his grand jury? It really doesn't matter. If he had previously not said it, said I didn't hear anything in the first trial and then magically heard it, that would be much more of a concern. So that's kind of where that case was. I've said this many a times, and I posted about it on Twitter. I refuse to call Twitter X. I won't. Is that documentary was one of the worst decisions I've ever seen a trial team make. And it's like, did you guys really not consider a chance that you guys, it might be a hung jury? It's like you just don't know. That when I watched that documentary with the word starting off, this is my testimony, it was pretty clear to me that the defendant thought she was going to be able to tell her story after she'd already been acquitted of this crime. But you can't do that. You can't assume that you're just going to be acquitted because even the best trial attorneys on the planet, especially ADA Brennan, is definitely one of the top trial attorneys in the country, for sure, is that they know that when there's a jury involved, you just never know what's going to actually happen. So watching that documentary and watching it just played, I cringe. I cringe and I like shake my head every single time I watch because it's like you have an absolute right to remain silent. You don't have to testify. Yet he's literally using your own words against you without having to put you on the stand and allowing you to the ability to contextualize it. It's almost like he's daring you to take the stand. And that might be a conversation that's going to be had to have. In the first case, it was pretty clear. She was never taking the stand. And why would she? It's like, why would you allow ADA Lally the ability to take free shots at you? The same could be said with especially ADA Brennan. I think he's done this whole case to basically dare the defendant to take the stand. Karen is very unlikable. Yes. I think I saw some report from one of the people from the jurors when they played the video where she mocks Peggy O'Keefe. She's just lucky that wasn't played immediately after Peggy O'Keefe's testimony. That's kind of what I originally said it was going to be stay out. And I figured over when I thought about it in the evening after, I was like, Judge Canona is going to have it in the morning because she knows that if they play it not right after Peggy O'Keefe's, it's not going to have the same prejudice it would have if it was like you have a sympathetic victim that Alan Jackson couldn't even cross. And then it's just like watch the defendant mock somebody who just lost her son after previously losing her daughter. It really Um, it would have been really something, a really powerful moment. But I did see here, I think I read somewhere that one of the jurors jaw dropped when they saw that clip, because it's so unflattering, it's so ridiculous, and it's just like, why do you have to like make a mockery of a woman who's just lost everything? And it's just it goes along with this whole theme about how self-centered arguably the defendant is. We heard about, it's like, oh, when she's talking to, I think it was Watley, whatever his name was, and she's saying like, not about John, it's like, who's going to take care of the kids? I'm not taking care of the kids. And it's like, I don't know if in this very moment this is what was needed. And the testimony going after, if you know Carrie Roberts, it's like, again, this woman got up at 5 a.m. in the morning, um, and is helping you when she barely knows you, because she is very close with your boyfriend. And she wants to help you, even though you don't know each other that well, and you're already trash talking her behind her back. And eventually, I know the clip where she gets arrested for second degree murder, and she's like, I can't have these shoes, I'm going to be on channel 4. That's going to be on there. It's just going to be woven throughout the case that this is not a likable person, this is a self-centered person. And that's kind of allowing the jury to kind of concoct their own motive for what happened. And what I think ultimately Special ADA Brennan is going to argue is that the defendant, and I think he already did during opening, I think he did in a previous hearing, that Officer John O'Keefe broke up with Karen Reed and her ego couldn't take it. And that it was like they had already heard, the niece and nephew overheard that the relationship had already run its course. The defendant, they were fighting. It was pretty clear. Like the examination, I think it was today, of the friend, it was like, okay, were they fighting? Oh no, it was cordial, blah, blah, blah. There wasn't any of that. And then boom, Yannetti walks right into it and allows Brennan to talk about the night in question and give a more clearer picture of what happened. So it was just, it feels like Special Agent Brennan is allowing the defense to just walk into his trap every time. And Alan Jackson's a lot smarter than David Yannetti, and Yannetti just walked right into that. And I think it's just going to be a brawl throughout the entire case, because it's like, Jackson makes a point on cross. Oh, inconsistent statement. Oh, all right. Got to take a note of this. And then defendant be like, yeah, I did say I had him. Or it's like, oh, because in the first trial, I remember they were trying to claim like she wasn't intoxicated. And I was looking at the video. I'm like, this is like 9 drinks. This is not the hill to die on. And then, of course, she does the documentary and she's listing off, yeah, didn't take any highways or anything like that. It's like, okay. In addition to all the drinks, I had like 4, but it was really 6, and then were shots. I was like, really? Like, did nobody in your defense team is like, maybe we probably shouldn't say that. Well, why don't we do this after this whole trial is over with and you're acquitted? And that's kind of, yes, seeing Brennan is 10 steps ahead of the defense. That's kind of what I've got, that he's allowing that. A perfect example, since it's draft night tonight. Darrelle Revis, one of the best cornerbacks in the league, in the history of the league. He would, before every single season, he would get a list of all the wide receivers he would face, because he would face the number 1 receivers. And he would spend a week for each receiver watching every route that they would do, so that when game day came, he would run the routes with them. And that's kind of what Special ADA Brennan is doing. He's knowing exactly from his experiences as a criminal defense attorney, knowing exactly what Alan Jackson or David Yannetti are going to ask, and basically allowing them to walk into it so that he can clean it up and redirect and then show the clip. And then any kind of points they got was completely gone. AJ looked defeated during the video. Yeah. For the longest time, I couldn't figure out why they didn't have the same swagger. The first trial, yeah, sure, they would they would walk into the courtroom and they're like, yeah, we got this. Obviously they're under a gag order this time, so it is different. But I thought it was like with the Lexus date or something different. And that may be true, but I think that they know they're just going to get clobbered by with the defendant's own statements, and they just don't paint her in just a flattering light at all, by his own admission. And he is right. It doesn't. How is the defense going to defend their client when she's basically testifying for the Commonwealth? She's backing up the prosecution. Yeah, I just recorded a podcast for Law and Crime. I think it's Karen Part 2. I did Part 1. I did Ashley Benefield, so they asked me to do this one as well. And what I said, and this is very important, the absolute worst witness in a criminal case is yourself. And what's even worse is you're not even on the stand to contextualize anything. Your literal own statements. You're on a body cam admitting to everything. You're on video doing the crime. That's who the worst witness is. So every time she speaks, you can guarantee the jury is glued to them. They were glued to the TV every time she spoke. Is painting a picture of Karen a terrible person to offset Proctor's upcoming testimony? I think that I don't know if that's necessarily the goal. I think the goal is they're trying to put in a mindset, this individual capable of murder? That's what the jury's going to be questioning, because in the first trial, we really, with the exception of the backwards acceleration, we really weren't it laid out what actually proved for the murder crime. They really didn't. They were pretty lucky that they didn't actually get acquitted, or like the judge didn't JOA. It was a very weak case. So I think they're laying the foundation of this person. That's like, this relationship is over. This is a self-centered individual. This is a highly egotistical person. And this person could have reasonably not been willing to accept that Officer O'Keefe is ending their relationship. That's kind of what I think the Commonwealth is thinking. Caught you on Law and Crime today. Question on the murder charge. Hank stated he would appropriately charge Karen. He left murder charge on the table. Can we interpret that as he might have something? Yes. Hank Brennan is an exceptionally experienced trial attorney, and he would not. And if he said we need to drop the murder charge and go on manslaughter, Michael Morrissey would have allowed him to do it. So it's definitely, I have to think there's got to be something on the vehicle data. There's something that the Commonwealth didn't present in the first trial that they're going to do here. My personal belief is, I think I said this, I think I said this to a couple of producers. For me, when you watch the video of her backing up into Officer O'Keefe's vehicle, she's turned around. Her head's turned around. So it begs the question, okay, you know how big your vehicle is. You're more sober than you were at 12:30, understandably. Why do you, and you're backing up. Why are you, you know that vehicle's there. You don't even try to avoid it. There's no turning of the steering wheel. It's almost like she backs up into it on purpose. That begs the question. It's like, oh, you knew your taillight was cracked before this, and now you're trying to create a taillight. That's always what I thought. There's got to be something that the Commonwealth has not presented, that, or maybe they had and they never really flushed out in the case. Because for me, that if you can prove the defendant and show with data that the defendant maybe overrid her backup camera and backed up into the car on purpose, that would reasonably assume, it's like, why would you be doing that? Why would you be doing it on the right side of your vehicle? Exactly. Not to mention a vehicle would be beep, beep, beep. This is a Lexus. This is going to have a backup camera. This is not going to be something where she's looking back and be like, oh yeah, no, I can't. Everybody, I'm from the Commonwealth of Massachusetts. We've all driven in the snow, and we know that we need to negotiate that term long before, because our vehicle could get stuck. So it's like, why is she not even, she knows the vehicle's there. She had to have pulled in the night before into the garage after this whole happened without avoiding the vehicle. Why, when she was way more drunk, why, when she is more sober, does she back up directly into it? And that's kind of the questions that the defense really doesn't want anybody to answer. So that's going to be the point of contention. The fact that none of the taillight was found at One Meadows. It was found, all of it was found at 34 Fairview. It's literally in the snow. And it's just a lot of things they're going to have to explain. I have a Toyota backup camera, warns if you're too close to the bottom. Yeah. And one of the things I actually thought I read was that the Lexus would have not allowed you to back up. So I can tell you, my parents used to have an Audi A8. And I remember I'm driving my Nana and Papa, I think it was to the hospital, because my Papa had to get treatment for prostate cancer. This was years ago. It was like 10 years ago. And the vehicle had automatic braking system. So if you got too close to a vehicle and you didn't hit the brake, it hit it for you. That was the only time it ever happened to me. And it literally I wasn't even that close. For whatever, I think it malfunctioned and it literally hit the brake so fast that my papa like kind of almost flung right into me. He was wearing a seatbelt, but it was still like, it was still kind of scary. So it's like, if these vehicles had the ability to warn you, why is the defendant not doing anything to try to prevent hitting the vehicle? So it is. So for me, that's kind of, I think the vehicle is the whole murder two charge. If that data shows that maybe she overrid the um, kind of the backing up the collision feature of it, and if she did it like when she actually did the pedestrian strike, that's where the murder two charge is. I have a feeling Hank Brennan would not have gone on this case on murder two if he didn't know he had it. Because when having been a criminal defense attorney, he knows what's going to actually convince a jury and what's not, and when it is enough and when it's not going to be. Um, hey man, true crimes, our new Toyota does all that in big. So Lexus, yep. And I think that's where this case is going. And I that's what I'm feeling is going to be the prosecution's argument. The case begins and ends with the vehicle. If that data is explained and flushed out, and the jury's like, "Wow, I wasn't even sure if she did." If they can flush that out, it's not going to matter all the other stuff. They're going to be like, "No, we're going to put that together with the admissions, with the piece of the taillight on his clothing." Yes, that was the thing. Her ABS would have stopped it automatically unless she physically turned it up. There it is. That was one of the things. I think that's what I saw with that particular Lexus. So if she overrid it when she was about to, and if he has the timing down, where it's like, oh, we saw the video, it's like at this time, what's the timestamp on the Ring video? And she overrid it at this time, boom. Why would she do that? And then the jury's like, she's trying to crack the taillight so that she has plausible deniability. Begins and ends with that. I think the evidence is still pretty strong for manslaughter, but the vehicle is how you're going to make the murder case. It's just that simple. Have newer cars were featured, they're going to know. Yeah. And that's something that's in the jury instructions that you can rely on your common sense. And yes, that documentary is a gift that keeps on giving. Again, that was one of the worst decisions I've ever seen in a trial team make. It's like, let's just have a vanity exercise where we talk about how great we were. This is free marketing for me. It's like, Alan Jackson, you've represented Harvey Weinstein and Kevin Spacey. Why do you need to turn this into a free marketing tool for yourself? You just put your client, you basically have your client testifying against herself without her ability to actually explain herself away. So she's not going to want to, but she may have to testify. Is having a person from Ring come in to testify, I don't know. And if he does, we'll show the deleted videos. I've always wondered that. Where did that video go? Because one of the things, and also what I think I mentioned this previously with the documentary, that video is pretty clear. You can see the vehicle. If that video is able to catch everything out there, wouldn't we see Trooper Michael Proctor and Yuri planting the taillight, picking up pieces of the taillight there and taking it to 34 Fairview? If that existed, we would know about it. So I'm pretty safe to say that that didn't actually happen. I think he admitted 140 clips. Yikes. Yes, I know that the defendant wanted the documentary. She's like, this is my testimony, but somebody needed to explain to her, is like, if you don't win, expect every single clip to be used against you at trial. So who else? I think we could just talk about, could she have the right to appeal for an ineffective assistance? No. The appellate court's not going to buy that. And an ineffective assistance is when your attorneys are so bad that they are literally not acting as their attorneys. Doing a trial strategy and it not working is not grounds for ineffective assistance of counsel. Her ego is going to get her in the end. Yeah, that seems pretty clear. I think we'll just talk real quickly about the Kerry Roberts testimony. So they decided to actually cross her this time. Better decision, but I don't know how much damage it is. It's pretty clear that they're laying the foundation to go after Jennifer McCabe. I think they're going to say that she influenced her decision making. That's eventually going to happen. What else? And I think that the aggressive crosses they need to like pull those back. They did a good job with a more subdued cross on Kerry Roberts, but every single witness who's a man or you think that's part of this conspiracy doesn't need to be aggressively crossed. I think you're only going to get the green light for Trooper Michael Proctor, maybe Jennifer McCabe if she Hank Brennan's going to prepare Jennifer McCabe better this time and not have her come off like screeching and just kind of like annoyed. That's just something you need to do. It's really frustrating to be accused of all these crimes and your life been the living hell for 3 years. But the jury, you play right into the defense's hands if you allow that. And I just don't think Hank Brennan's going to do that. So I think that next week I'm actually going to be off next week. I am taking a much needed vacation. Yes, it's during the trial, but there is more to life than the Karen Reed case and everything that goes on. But real quickly, I want to discuss the NFL draft. I have 3 clients who are going to be potential day 3 draft picks, undrafted free agents. And it's kind of interesting, real quickly, that when you're talking with teams, they like call you up and, hey, what do you think about them? What do you think about this fit? And you're just trying to match teams. Like my clients and I, so draft starts in 2 hours, 44 minutes. My guys aren't going to be drafted tonight or tomorrow, but players that could affect where we decide to choose if they go undrafted does matter. If, say, they draft one of my guys as a running back, team takes a first round running back, probably not going to be a priority team. I have another one who's a defensive end. And if they take they take 2 defensive ends in the next few days, probably not a team to prioritize. So it's really interesting watching players and kind of being part of that. I don't know, being part of the brotherhood of the National Football League. So if there aren't any more questions, I'll give like another minute and somebody wants to get any last minute questions in because I got to go watch my daughter. So I've been fortunate enough to be able to do this, but she needs me now. So everybody have a wonderful weekend and happy draft day. And I'll see you guys when I get back on May the 6th. I'll be still tweeting. I'll still be tweeting here and there, but it's not going to be as vigorous. Thank you, everyone.